Hello, everyone. Welcome back to SEC Roundup. As always, I have with me the co-founder of ICAN, Nick Morgan. Hey, Nick.
Hey, John.
And our special guest is a partner at Paul Hastings, Igor Timofeyev. Good morning, Igor. How are you today?
I'm good. Good morning, Tom.
We're delighted to have you talk about an issue that is boiling up to the Supreme Court, and that is the Liu decision, or at least interpretations of the Liu decision. And for a minute of background, Liu is a Supreme Court case decided in 2020, which said disgorgement is like a penalty in some circumstances. And one of those circumstances is where there is a lack of pecuniary harm to the purported victims of the fraud. So with that, Nick, why don't you give us a little background of where we are? It's about 5 years later, where we are today and what's happening with the courts.
Yeah, well, Igor will talk about some of the other cases that are bubbling up in other circuits trying to interpret Liu's decision on disgorgement. But this particular case, and the reason we're getting it together today, is an enforcement action the SEC brought against an investment advisor, Navellier Associates. Case was filed back in 2017, I think. It relates to some conduct. It goes back even further to events in 2010 to 2013. And for people following the investment advisor space, they'll remember a cluster of cases the SEC brought back then involving something called F squared. It was essentially a vendor that was selling an investment tool to advisors and was purporting great returns if advisors used F squared's models. The problem, according to the SEC, was that F squared's models didn't actually do what they purported to do and had some performance numbers based on hypotheticals and backtesting, all of which wasn't disclosed. So Navellier Associates, the investment advisor in this case we're going to talk about today, was apparently one of the advisors that used that model. According to the SEC, Navellier knew that F squared's models were not what they purported to be. And Navellier nevertheless used the models with its clients. So SEC brings a fraud case against them, prevails in part on summary judgment, and gets a judgment in the case. So this is a federal district court case, imposing the usual assortment of remedies against Navellier, but it included disgorgement of $22 million and civil penalties of $2.5 million. The disgorgement here, $22 million of disgorgement. And remember, disgorgement is supposed to be disgorgement of ill-gotten gains. And Liu confirmed the SEC's ability to get disgorgement, at least when the award is limited to net profits and the amounts are distributed to victims. So here, the $22 million represents not losses by investors who worked with Navellier, but the fees that Navellier charged. So according to Navellier, the investors actually made a profit to the tune of like $20 million or something over this period of time. So the fact that there are no pecuniary harms, at least in Navellier's take on the case, tees up this Liu issue. And so Navellier appealed to the First Circuit, and First Circuit sided with the SEC. And then late last year, Navellier started seeking review from the Supreme Court, and that's what Igor is going to talk about. I think that brings us up to date, although I'm going to leave my part of the discussion with a number, and I want to revisit this number when Igor is done. So the number is $4.6 billion. I'll leave it at that.
Okay. Well, that's tantalizing. So Igor, you're the appellate guru. Tell us a little bit about what's happening in the appellate courts and with the Liu decision and what predictions, if any, of the Supreme Court may do.
Sure. Happy to do it, Tom. So to start, kind of like the issue that is now dividing the circuits is based on the Supreme Court observation in Liu that disgorgement is a remedy that must be awarded for the victims. And so Supreme Court was very emphatic that any money that the SEC or another agency gets for disgorgement cannot just be deposited into the general treasury fund, but it actually must be returned to the victims to compensate them. And so I think the circuit courts are now grappling with what this requirement that disgorgement must be awarded to the victims really means. So the Second Circuit in Govil took a position that in order for there to be victims, there must be a showing of pecuniary harms by the investors. And the Second Circuit emphasized that otherwise, if you don't have the pecuniary harm to investors as a prerequisite for disgorgement, then you will have a situation of overcompensation and not actual compensation. And so the Second Circuit, going through the history of the statute, said that actually fits with this kind of very peculiar but equitable nature of disgorgement. So in Navellier, the First Circuit took a contrary position. And the First Circuit actually expressly disagreed with Govil and said it does not believe that the showing of pecuniary harm to investors is a necessary requirement of disgorgement. And that's because the First Circuit viewed disgorgement as a profit-based measure of unjust enrichment. And so the First Circuit said, based on its own precedent and based on its reading of the Supreme Court's decision in lieu, it said that disgorgement is designed to deprive the wrongdoer of unlawful profits. So as long as there are unlawful profits and there is some intention to, if feasible, return these profits to the defrauded investors, the First Circuit held that actually disgorgement is a proper remedy. And then the First Circuit also noted, as Nick mentioned earlier, that in that specific case, it did see that there was a direct harm suffered by the individuals who were defrauded because they paid advisory fees and they were induced into paying those advisory fees as a result of the alleged or now found misrepresentations. So in its response, so then Navellier filed a cert petition, and its response to the cert petition, the SEC took a very clear position that it believes that the First Circuit approach is Navellier is right, and that it disagrees with the Second Circuit's approach. And it's interesting because the SEC filed its response, obviously, after the change in the administration, but nevertheless, they adhered to the position that was espoused by the SEC during the Biden presidency, and now the SEC is advancing, and the Solicitor General who filed a brief on behalf of the SEC, they now in the Trump administration are adhering by the same view of what disgorgement is, or what disgorgement requires. So the SEC said that it believes that the two decisions are in tension, that the First Circuit correctly interpreted disgorgement as not containing any pecuniary harm requirement, but the SEC then also said it doesn't believe there is a square conflict between the two decisions, and that is because they involve different types of investors. So the SEC said Navellier involved investment advisors, and then Govil involved a seller of securities. So, and also just to kind of like add something, is there are two additional cases that may deepen the split. So there is a decision that the 11th Circuit issued in last year in 2024, and it's a decision that postdated Govil. It did not discuss Govil, but it adopted the similar view of disgorgement as the First Circuit now adopted in Navellier, as not requiring a showing of pecuniary harm. So there is a case that the 11th Circuit has also sided with this view of disgorgement espoused by the First Circuit. There is also a pending appeal that Nick and I are involved in the Ninth Circuit, where the Ninth Circuit heard argument in early December. And that appeal also involves the question of whether or not pecuniary harm is required before the SEC can impose disgorgement. So whichever way the Ninth Circuit rules, that decision may further deepen or expand that split that currently exists between the First and the Second Circuit.
That's tremendous. Now, what's the procedural posture of the case? Has the Supreme Court accepted cert?
No, not yet. So the SEC filed its response just a few days ago on May 5th. And so on the Supreme Court's process, the petitioner, Navellier, now has at least 14 days to file its reply. And then afterwards, the Supreme Court will distribute the petition, the response, and the reply to all the 9 justices and their clerks. And so that distribution will actually happen on May 20th. And then the justices will consider the petition at that conference, which is scheduled for June 5th. And at that point, they can make a decision whether to deny the petition or to grant cert. If they make a decision, then it will be announced within a few days when the Supreme Court releases the results of the justice deliberations at the conference. The justice may also decide to take some additional time. So sometimes one of the justices may see some issue in the petition, may want to take an extra week to look at it, or until the next conference. Sometimes the court wants to check if there are any procedural barriers or any procedural wrinkles before they make the decision. So sometimes some of the decisions are also held over until later. And just to remind everyone, there were 9 justices, but it takes only 4 votes to actually grant a cert petition. So because obviously if it were a majority, then the Supreme Court could make a decision automatically. So if 4 justices at that conference vote to grant cert, then that petition will be granted. It will be followed by a briefing on the merits, and then the argument will be scheduled sometime in the court's next term, which will begin in October of this year. The one other just point to make is, even though there is this split that the First Circuit acknowledged with the Second Circuit and that the ECC acknowledges, when the justices consider a petition, they also want to make sure that the question on which the courts of appeals are split is directly implicated in the case. And so in this case, as I mentioned, the Solicitor General of the SEC argued that even though the 2 decisions are in tension, the Navellier decision does not squarely present the split because of a different type of investors that implicate in the 2 cases. So that fact, the question whether or not, in fact, this is an ideal vehicle for the Supreme Court to resolve a split, may also bear on whether the justice will grant the cert. Sometimes, even if they see a question that they think the Supreme Court should resolve, they may wait for a better case that presents a better vehicle to address it later on.
Well, the Supreme Court has shown a lot of interest in SEC enforcement cases, so maybe they'll take this one up as well. Okay, back
to my
to your number.
Right, $4.6 billion. $4.6 billion relates to a special account that the SEC has at the U.S. Treasury. So Igor mentioned that following Liu, there's at least a colorable understanding that the SEC will distribute disgorgement that's collected from defendants back to harmed investors. But in fact, that has largely not happened. So there is the SEC has collected huge amounts of penalties and disgorgement over the last, say, 5 years. And when it can't distribute that money to harmed investors, sometimes because they are intending to distribute it to, but they've collected it anyway, it sits in this special account in the Treasury. So every year the SEC puts out its annual report, and every year since 2020, this held for distribution account gets bigger and bigger. In 2020, it was $2.4 billion. 2021, it was $3.1 billion. 2022 is $3.9 billion. 23 was $4 billion. And then last year, $4.6 billion. To put that in perspective, the SEC's entire annual budget is only $2.1 billion. So this amount that's being held for investors just gets bigger and bigger. So if the SEC prevails and actually collects any money from Navellier, I don't know where it's going to go eventually, but for some foreseeable future, it's going to sit in its Treasury account for the benefit of no one except maybe the U.S. Treasury. And then the last point I wanted to make was the impact that this case has already had and will have on investment advisors specifically. So in this case, there was a fraud that did not harm investors, and the SEC obtained disgorgement of all of the fees earned by the advisor over the period of time the fraud was taking place, in spite of the fact that there was no harm. So I think it was a little disappointing to see the current SEC take this position, because it seems to suggest the SEC everywhere outside the Second Circuit will feel unconstrained by Liu to obtain disgorgement in cases where an investment advisor has not actually harmed investors. So that's a note for investment advisors to keep track of, particularly if they're not in the Second Circuit.
Yeah, well, hopefully the courts will continue clarifying Liu in a way that helps us and doesn't help the SEC. And may the next case be your Ninth Circuit case. And with that, we'll conclude this episode. Igor, thank you so much for joining us and for your insights into the appellate process as this case moves forward. And Nick, always a pleasure to be on the panel with you. Until our next episode, we'll see you all later.
Thanks very much, Tom. Pleasure.